Ladies and gentlemen, welcome back to the Black Health and Wealth Show. I am your host, Kevin Boyette, and today I am honored and privileged to be with Suren Adams. Suren, thank you for joining us today. And today we're going to be discussing estate planning. Estate planning, you know, something that I feel is very important, but I'm going to let the expert here go into more detail and more specifics on why you need to start planning your estate. So, how long have you been doing estate planning?
Estate planning for over 12 years now.
Okay.
Quite a while.
Okay. So we were talking a little bit off camera that estate planning is one of those things that people really don't want to discuss. Mm-hmm. So because they think it's coming close to the end.
Well, yeah. A lot of people, it's something people put off often. It's something people don't necessarily want to think about, but really it's a gift for your family members is what you're doing. You're planning ahead so that when the time comes, and it will come for all of us, that you're not leaving a mess for your family members. You're leaving something that's structured in order, showing that you had forethought, you planned for them, and leaving it in the best way that you can avoid things like probate or estate taxes, all of those things that are unnecessary if you plan ahead.
Okay, now you mentioned probate, and probate is one of those things that I'm kind of iffy about. Some people have to go to probate, some don't. What determines that?
Well, if you pass away without a will, you definitely have to go through probate. A lot of people don't know, though, if you pass away with a will, you still have to go through probate. The thing that avoids probate is having a revocable trust that's fully funded with all of your assets. So probate is essentially where the court supervises the distribution of your assets to your family members. If you have a will, they still need to supervise that the distribution from what's in your will is what is actually happening. And the process can take anywhere from 7 to 12 months or longer, depending on the estate. If you, instead of leaving just a will, you have all of your assets in the name of a trust, a revocable living trust or an irrevocable trust, then the trust actually owns your assets. So when you pass away, there's nothing that you own individually. So the court doesn't have to supervise that. You've already stated in a separate agreement. It's almost like setting up a separate entity that's going to manage your assets. You've already stated in that what happens with your assets and your distribution and who gets what, when they get it. So the court doesn't get involved in it unless something occurs that's outside of what you've set to do and somebody has a need to bring it to the court's attention. Yeah,
because they say there's always a lot of drama with weddings and funerals, so this is one way to avoid that.
To avoid it,
okay.
Exactly.
Okay, so you mentioned revocable and irrevocable trust. What's the difference between the two?
The revocable trust is one that you can change while you're alive. So as long as you're competent and living, you can make changes to it. You can take assets out of it. You can put additional assets into it. You can change beneficiaries, trustees. You can make whatever changes you want to. An irrevocable trust is one where you put assets in it and you essentially are losing control over those assets. It's generally done in larger estates where you know that you're not going to need these assets in order to live off of it. So if your estate is $10 million, you know you're only going to need $5 million. You can put a portion of your assets into an irrevocable trust. You leave it for the beneficiaries that you want to designate and the distribution pattern and all of the details you want in the trust, but it's basically hands-off. You're no longer trustee of the trust. You're no longer a beneficiary of the trust. It's left for the beneficiaries that you name outside of yourself.
Okay, so with that, so you were mentioning a will, and so this is in addition to the will?
Yes. When we do a trust plan, the trust is the primary tool that's used to show who gets what. We also do a will with a trust plan because it's called a pour-over will. So that if there's assets that you've forgotten about, like if your mom set up a bank account for you and never told you about it or something like that, and that asset never gets funded into the trust, the name of the trust, then on your passing, that's something that's going to have to go through probate because it's individually owned by you. So in order for that to happen and to be administered properly, you have to have a will in place to let the probate office know what should happen to it. And essentially we say in a pour-over will, those assets get poured into the trust after your passing so that everything then gets distributed according to what you have in the trust agreement.
Okay. Now, when you have that trust agreement and you have your beneficiary set up and those kinds of things, what happens when beneficiaries show up that no one knew about. Like, for example, when Charles Kuralt died, and he had this woman that he was, you know, seeing in Montana for 29 years. The wife didn't know about it. The kids didn't know about it. You had land and all this other stuff. How do things like that get handled?
Yeah, the benefit of a trust is that the beneficiaries you name in that trust, they're the only people who are going to get anything out of your estate plan. Obviously, people can contest an estate plan, but the thing you should be concerned about is, will this person be able to win a lawsuit contesting what I've said in this plan? And it's very unlikely that if you've set up a trust during your life when you're competent, you've been managing assets under the trust for a period of time, you funded assets into this trust, maybe taken assets out, done all of these things with this document, that a court is going to say, no, they didn't mean to do this. We're going to overrule what this person has said and then pull this other person in. It doesn't go through a probate process, so it would have to literally be somebody suing the trustee of your trust saying, no, I think I should be part of this estate plan, and it's very unlikely that somebody contesting a trust plan will be able to win because of the fact that it's something that you create and manage assets through while you're alive.
Okay, now, should the average person, like the average homeowner and stuff like that, put their home, cars, things like that in a trust, like at an early age?
It depends on the asset. So in this area, many homes are underwater. That would be an asset you don't want to necessarily put into the name of the trust, because you're essentially putting in the trust a negative asset that the trust will then have to pay off. If you leave it outside of the trust, and then when it has actual equity, when it becomes a positive asset, then you can put it into the trust. But the age of somebody and the number of assets, it really is whether or not you want to avoid probate, bottom line.
Okay.
If you have any assets at all, a trust is a way to avoid probate for your beneficiaries. So whether you're young or old, having a house that has equity in it, yes, I would recommend doing a trust plan. Some sort of estate plan is necessary really for anyone over the age of 18, because the other parts of the estate plan would include a durable power of attorney and an advanced healthcare directive. The durable power of attorney names an agent who handles your financial decisions if you're incapacitated, or things like doing your taxes if you're incapacitated, collecting your mail, going to the bank for you, all of the things that people end up doing illegally for their family members if they're even in something like an auto accident, or you break your arm and you can't sign something for a while. All of those things, you need to have a power of attorney in place. So as long as you're of legal age, you need that regardless of whether you have assets. Same for the advanced directive, which is a medical power of attorney.